I heard rumblings about a game that might be of interest. My name is Dana Middleton. Take two. Just kidding. My name is Judge Dana Middleton. I was recently appointed to chair this committee this past December. But I do want to welcome everyone to the May meeting of the Maryland State Commission on Criminal Sentencing Policy. So I do want to welcome everyone and thank you for coming this evening. First, I would like to share a few dates regarding the membership, which is changed just a little. First, as you may recall, there are multiple commissioner 4-year terms, which expired in 2023, including the term for chair, the circuit court representative, the law enforcement representative, and one of the 2 public representatives, as well as the criminal defense attorney representative. First, I'm pleased to share, not about me, that the Chief Justice Fader did appoint Judge Brian DiLeonardo to continue with the commission as the new circuit court representative fulfilling Judge Avery's position. So thank you so much for staying. This is Judge DiLeonardo's 3rd position on the commission. He started serving as the state's attorney's representative and then the chair. So thank you. I do want to add that I've had several conversations with Judge DiLeonardo. He's been extremely helpful in helping me transition. I do rely a lot on him. So thank you so much. Additionally, we want to welcome Richard Gibson, the Deputy Chief of the Westminster Police Department, who is serving as the law enforcement representative on the Sentencing Commission. So welcome and thank you. Mr. Gibson was appointed by Governor Moore on December the 12th, 2023. Next, I want to welcome Mr. Rodney Davis. Mr. Davis was appointed as the new local corrections facility representative by Governor Moore as well on December 21st, 2023. He is the institutional training coordinator for the Baltimore Central Booking Intake Center. Welcome, Mr. Davis. And last but certainly not least, we want to share that Mr. Finchy was reappointed to another 4-year term as the criminal defense attorney representative to the Commission on Criminal Sentencing Policy. He was reappointed on December 4th, 2023. We would like to acknowledge that this is his 6th term, and 2024 is his 21st year with the Sentencing Commission. So congratulations. Regarding subcommittee leadership and vice chairs, as you know, Judge Avery's term with the Sentencing Policy Commission concluded in December. Judge Avery completed 2 full 4-year terms as the vice chair of the Maryland State Commission on Criminal Sentencing Policy and served as chair of the Sentencing Guidelines Subcommittee for the same 8-year duration. I asked Judge Melanie Shaw to serve as the new vice chair of the MSCCSP and to serve as the co-chair of the Sentencing Guidelines Subcommittee along with Judge Brian DiLeonardo, and they both accepted. So I want to make that announcement as well. Thank you so much. Judge Shaw did inform me that she would not be able to make tonight's meeting. Anything else? No, and that concludes my announcement. Thank you. At this time, we do have a quorum?
We do have a quorum.
All right. Has everyone had a chance to review the minutes? Okay. Can I have a motion to approve the minutes?
I'll make a motion to approve the minutes.
Second? Thank you. It's been moved and properly seconded to approve the minutes. All those in favor?
Aye.
All those opposed? Thank you. Minutes have been approved. Thank you. We will now move on the agenda to the Guidelines Subcommittee report. Judge DiLeonardo, and Judge Shaw's absence, do you mind giving the report?
Sure. Well, we had a number of issues, some of which we had taken up in the big committee before regarding misconduct in office. We did that in December meeting. So with that, I will turn it over to Dr. Soule for the report.
Appreciate that. Yeah, the guidelines subcommittee met in April to discuss the two issues that you see before you on the agenda for the guidelines subcommittee report. And like a good leader, I'm also going to pass it on. So Stacy is going to lead the discussion for the first item, which is the review of the seriousness category for misconduct in office.
Sure. So I will direct your attention to the memorandum for tonight that's titled Review of Misconduct in Office. In addition, you received comments from Sarah David in the Office of the State Prosecutor. She was not able to attend, but wanted to share her thoughts on the issue and has indicated that if there are any questions, she's happy to answer those following the meeting. So, as Judge DiLeonardo mentioned, last year the Commission considered a request from the Office of the Maryland State Prosecutor to add a guidelines enhancement for offenses involving the abuse of a position of trust. After hearing from the OSP and reviewing the available data, the Commission concluded that an enhancement would be contrary to the descriptive nature of the guidelines and that the legislature is better positioned to address the OSP's concerns. However, the Commission did agree to consider a more stringent seriousness category for the specific offense of misconduct in office, as well as ways to obtain more complete data for offenses involving the abuse of a position of trust. Accordingly, the subcommittee met on April 22nd, 2024, to discuss these two items. Regarding the first item, the subcommittee requests that the Commission consider its recommendation by a vote of 3-1 with one abstention to revise the seriousness category for misconduct in office from 5 to 4. This recommendation is informed by the guidelines data and comparable offenses, both of which are summarized in tonight's memo, and is based on several observations of note. First, nearly all individuals sentenced for misconduct in office have no prior record. Thus, the recommended guidelines range for most individuals starts at probation, and for more than 1/5 of individuals, the range only includes probation. Consequently, when departures occur, they are nearly always above the guidelines range. For example, over the last 10 years, 17% of sentences were above the upper guidelines limit, while only 1% were below the lower guidelines limit. Lastly, even though most ranges include probation, the average non-suspended sentence is 11 months. The memo for tonight also includes several examples showing how the guidelines would increase if the seriousness category was changed from 5 to 4. The first set of examples, which are on the screen here, provides 4 scenarios where the misconduct involves an offense against a person and the defendant has no prior history. And I'll just go over a couple of these examples. In the first example, there's no injury, no weapon, and no special victim vulnerability. And the range with the offense is a seriousness category 5, which it currently is, would be simply probation. And if the offense moves to a category 4, the range would increase to probation to 2 years. At the last row of the table, if we add in non-permanent victim injury and a firearm, the range currently is probation to 3 years, and that would increase to 1 year to 6 years. The second set of examples that we've provided display 2 scenarios where the misconduct involves a property offense. In example 1, where the defendant has no prior history, the range would increase from probation to 6 months to probation to 9 months. And in the second example, where the individual scores 1 point on the offender score, the range would move from probation to 9 months to probation to 1 year. Regarding the second item, that is data collection, following the last commission meeting, the staff and the OSP corresponded about potential options for getting more complete data for offenses involving the abuse of a position of trust. And the staff is pleased to report that the OSP has offered to work with the local state's attorney's offices to retroactively identify and collect information on such offenses. As a result, no additional action from the commission concerning data collection is requested at this time. So again, at this point, that concludes my summary. I'll turn it over to the commission for discussion. And again, the subcommittee is requesting changing the seriousness category of misconduct in office from 5 to 4.
Thank you, Stacy.
Is there any discussion?
I guess I could start and then I don't know. So this was an issue, as I said, when it was brought up in December. And I think there was agreement among the commission that doing a separate enhancement as requested would be more of a proactive dictation rather than reflective. But one of the issues, just to put a point on it, is that historically we've had issues of classifying common law offenses, which is a little different than something that is easier to do when we have a specified penalty. And because of that, that was one of the discussion points that came up last time, is perhaps to take a look at this. Was this common law offense properly classified? So that was the discussion. I think that was had in the committee. One of the points I just would raise as to why I was in favor of this change that is recommended is if you look at the mean sentence as being 11 months, which to me, in all of the scenarios that were the prior slide that was up there, but all of the scenarios, that mean sentence would now be within the guidelines, where previously it would be over the guidelines. And I noted that strict compliance, 70% of the time they were above the guidelines when they were being sentenced. So I think as a reflective in terms of capturing what is likely, I think any judge is going to consider the facts. If this was a misconduct in office claim, would consider that in a different way than it would perhaps the way it was classified before in a different category. So I believe that is why the discussion that we had, there was 3 in favor. I think Judge Shaw had voiced opposition, and Mr. Finksy, he abstained to, I think, perhaps be prepared to give his thoughts today. So that's all I have to add.
My turn?
Yep.
So I abstained because initially this was brought to the commission because the state prosecutor's office, one of the main reasons they gave for bringing this to the commission was a plea bargaining process that they undertake, and that they felt that they were in a position of, I guess, weakness given the guideline range, the guideline characterization of this particular offense. Having been on this commission for so long and reminded about that tonight, one of the things that so many times came up in the past is that the guidelines should not be taking into consideration sort of that process that happens, in the trenches, when the lawyers are negotiating, and the guidelines are always used as a sort of starting point for negotiations and sometimes an ending point. Some prosecutors will never go outside the guidelines. So here we are in a situation where the commission is being called upon to stir up, I would say, problems with that process as it currently exists. And this commission has always taken the position that we should not get involved in that. So that was one major reason against it, that it was brought into us in that manner. On the other hand, I forthrightly said that when you look at the offense, and you look at the offense of perjury, which although carries 10 years, is it really, should they be characterized similarly? And so I abstained because I was still trying to decide in my mind whether this commission should look at an offense like this brought to us by prosecutors for the reasons so stated, and nevertheless sort of ignore that and perhaps look at the way other offenses are characterized and decide if they're similar or not. So that was why I abstained. Frankly, I still haven't made up my mind. I'd like to hear what other members of the commission think about that. I know Judge Shaw didn't think it should be recharacterized. I don't want to speak for her, but I think it was more the process of it being brought to the commission in this way. And keep in mind, we're probably talking about a lot of police officers who are charged. I mean, that's really the The major parties who are charged with this offense are police officers. There are others, but mostly police officers.
Yeah, and I'll just speak quickly to that point. I don't disagree, and that was, and I think I had said that, I don't believe that was a reason to make a change, the reason that it was proposed. But I guess I sort of separated out the reason we were looking at it from the merits of it. And I think just for the point you made, perjury, I mean, to not have it at least as the same classification of perjury, it seemed to me to be way underclassified. And I would also note that even with the change, all the guidelines still contemplate probation, except when we're dealing with a firearm situation, which, you know, again, we're probably in many of those situations dealing with law enforcement. We've seen those cases where, you know, they've abused someone in their care or custody. My guess is that would be a suitable guidelines for those situations. That's going to apply anyway, because we're already seeing 11 months being imposed by judges anyway. That was having the guidelines range of probation for some of them. So that was sort of, I sort of look at the data, and to me, that was my position, was the data really kind of warranted the change. But anybody else on the subcommittee?
Well, as a prosecutor, I don't believe that the manner in which it was presented to us was a legitimate reason to change the way the guidelines are scored for this offense. You don't like the way you're plea bargaining your cases, plea bargain is some other way. Nevertheless, I don't think that the current offense score reflects the fact that misconduct in office almost always, if not always, involves an abuse of a position of trust. And I think that factor alone justifies an increase on one level. So at the subcommittee, I voted in favor.
I guess, I mean, I was here for the discussion last time we had it. And it seemed to me that where we had settled as a commission, maybe I was wrong about this, but was that it seemed like a legislative issue. Because if the issue is that it's misclassified, right, in terms of the severity, statutory severity or whatever as a common law offense, then they should raise this with the legislature. And I don't know exactly where I fall on this yet, but you know, Judge Avery were here, right? She would, I think, would raise the issue. If I understand right, 90% of these cases are guidelines compliant. And if it's descriptive, right, we're supposed to be a descriptive commission. Then usually when we've made changes to the guidelines in the past, it's because we've seen some pattern of judges going above or below systematically. So if 90% of the time judges are sentencing in the guidelines, I guess it does feel like this is, I'm not necessarily against it. It does seem like it's too low for what it is. But it's hard to use the data to justify it if most of the time judges are following.
I have a couple, if I can, a couple of responses to that. So first of all, in terms of guideline compliance, you'll remember this has always been my bane for years, which is it doesn't reflect actual sentences. So it can be guideline compliant if we all agreed it should be probation, or we all agreed it should be 20 years, that would just be considered guideline compliant. What I look at is kind of the actual mean of the sentences, which is 11 months, which was, to me, kind of reflects where it actually is getting sentenced. And so that is why when I look at that, that seems to fall squarely within the seriousness category. So that's number one. And I agree, I share Judge Avery. We used to always make the same argument, and I agree with you. I don't think it should be a situation where we are being prescriptive. But I think that's why with the analysis that the staff did, making that recommendation, the argument was a bit different. The argument last time was they wanted us to ascribe a point if it involves a breach of trust. That would go across every category of crime. And it was much like what we did in scoring victim injury when it came to the pornography, the child pornography. This doesn't do that. It falls within our normal routine of having to properly classify crimes. And when it comes to common law, that's always sort of a bit of, I guess, an art rather than an actual, we can't fit it in like it's 5 years and, this is what it is. It could be anything. So I think that's the only differences I think that I found.
Any other comment? Yeah, if I may, and this may be more of a question for the data analyst who took a look at this. Bearing in mind exactly that point about please, I was wondering if you had any sense compared to analyses of decisions for other maybe broad classes of offenses, if it was more likely for these types of cases, given the sensitivity of the defendants maybe being at such a public trust, if you were always going to see a higher likelihood of these cases being settled by plea. That I think should really influence whether or not a sentence, a guidelines modification is the appropriate balancing maybe to that scenario. And my second question is just, again, given that scenario that a number of these defendants may be law enforcement officers, if you had any sense in the additional data gathering you're doing, how frequently that firearm weapons presence was a normal condition or was prevalent.
So regarding your first question, like relative to other offenses, whether it's more likely to be resolved by plea, I don't have that answer.
Stacy, 30% of them were ABA binding pleas, 31%.
Right,
Yeah,
now there's another 24 or 28% that were other plea agreement. And just historically, one of the problems we've had is all of those were lumped in to be guidelines compliant on the worksheets. So the data becomes a bit skewed because we just assume they're compliant. So they're in a compliant sentence, even if the actual sentence is outside the range, which is a problem.
Yeah, and regarding the presence of a firearm, 14% of these cases had points scored for firearms.
In which it was a person offense, not like.
Yeah, yeah.
Everything that's been said, I think it's been right on point. I mean, the one thing I just wanted to reemphasize, this is unique because it is a common law offense. So they have always been lifted for us to classify. We are primarily driven by comparables. What are comparables? Offenses that have similar statutory maximum penalties. Well, what do we do when it's a common law offense when we don't have that? So that is kind of the one thing that makes this offense more unique in terms of that. So when we look at the comparables, like Rick pointed out, is it comparable to perjury? Reasonable minds might differ on what the proper comparable is because the legislature hasn't said the statutory maximum penalty is 10 years, 15, whatever it may be. For this conduct.
So I apologize for not tuning into the details as this discussion was taking shape, but the Office of State Prosecutor is in fairly frequently seeking modifications to misconduct in office. So I'm always curious what the underlying cases are that they're trying to get at. And it sounds like a lot of them are police cases. And so that's its own thing. But the political cases are the ones I've been very curious about. Seemingly, I would say my colleagues seem to get very light and gentle treatment for conduct. I'll just put that out there. And I have, I don't know what my other legislative colleagues would say about that, but that has been my observation. I don't know how easy it would be to, throw a fix in there, but I have at various points in time suggested we actually just tackle the beast, because I don't like common law. I like codified clarity. But I would throw that out there, whether, this really ought to be a larger legislative project. Having said that, since this is before us and the work is here, I would hang my hat on, I see that interfering with the judicial process goes under 4. Great, let's line it up with that and sort of endorse that move. But I am actually very curious about this larger enterprise and whether we shouldn't be doing more, because as I know, they do seem to be in often seeking changes to this.
Isn't that also already being undertaken, some larger process looking at criminal?
Turn that, actually Senator West might be able to address that. Senator West did pass legislation and he sponsored this session, the task force to study crime reclassification. And one of the things I believe I remember correctly is this iteration is considering taking a look at common law offenses and whether they should be codified.
Yeah, I don't know whether you discussed it or not, but we passed legislation out of Delegate Moon's committee as well as mine to set up a 1.5-year study. Senator Sidner and I both, I think, voted in favor of it to try to reorganize the entire criminal code and associate apples with apples and oranges with oranges. And included in that study is studying the common law offenses to see whether or not they should be codified. And David specifically was included this year on the study commission. He needs another job.
Yeah, and to follow up on some of the comments that have been saying, I guess part of my struggle with this is that, you know, under the umbrella of this common law offense, we have what to me are like completely different offenses. Like if I'm thinking of a police officer who's abusing someone, abusing the position of office, discharging the firearm, and I'm comparing that to you know, Delegate Moon's example of a politician who is perhaps, you know, getting a job, you know, improperly. To me, those are completely different offenses. Yet they come within this common lesson, and so it's kind of why I'm struggling with this. And if you look at the property, at the changes, how this would result if it's a property offense, it's really not that much, you know, just a couple months on the one end. But if it becomes a person offense, the changes are a little more substantial. And so what we're doing is, I'm trying to see how a one-size-fits-all solution applies.
Can I read something for you all? I read their letter to the commission, and this is from the Office of the State Prosecutor, specifically paragraph 3 on the first page. Says our office's focus on political corruption and public officials, including police misconduct, makes us especially aware of the many allegations and cases that arise in Maryland involving this offense. Given the thorough nature of the commission staff's work, showing how this change is reflective of judges' current sentences, we want to focus our comments on the increase in allegations where misconduct in office is charged and the victim is an individual or a group of individuals, rather than the government or a subordinate government institution. Public scrutiny on police misconduct and sexual assault committed by people in positions of power has significantly increased over the past 5 years. Our complaints and prosecutions in this area have increased to a level where our office sought and received funding for a prosecutor and investigator to specialize in cases where sexual assault and official misconduct overlap. So it sounds like that's the primary, or one of the primary reasons that's driving them to ask for this remedy or something similar from the commission.
Well, I can cite a specific example that's contained in the letter from Calvert County, or around the state's attorney. We had a police officer who, in responding in his official capacity to a domestic violence complaint, offered to escort the female victim from the home, took her to a motel, and then engaged in sexual relations with her. It was not unconsented to, but it was still the crime of misconduct in office because he was on duty in his uniform. So the guidelines in that case were probation. I personally felt that did not, again, reflect the common factor that in all of the examples we're talking about, which is an abuse of a position of trust. So that is a specific example, very limited. Nevertheless, my feeling was the gentleman the guidelines did not reflect the severity of what that gentleman did.
If I could just add too, on that point, we're talking about in a situation like that, going from probation to 2 years, it's still all within the guidelines.
Right.
I think we're just reflecting that we're seeing 11 months as being the most, I guess that was the mean sentence, that would be reflective. And that's why I will say again, I don't think the reason for the request or why it's being requested to me has as much weight as the data reflects that we should make that adjustment when you look at the category of offenses that are similar, along with the 11-month being the actual sentence we generally see. I don't think it's going outside of the guidelines by making that change. I think it's appropriate. And to Mr. Harvey's point, I mean, that's just another example where if someone gave an 11-month sentence in that case, it shouldn't be above guidelines. Like it should be reflective that probation to 2 years, that would be within guidelines. So
The example I cited was handled by the state prosecutor's office, and the individual did get probation.
Other comments or questions? Does anyone wish to make a motion to amend the seriousness category with respect to misconduct in office?
I will.
Yes.
So moved.
I'll second.
That category from category 5 to category 4.
I'll second Mr. Harvey's motion.
Thank you. It's been moved and properly seconded to amend the seriousness category of the offense of misconduct in office from a seriousness category 5 to 8. All those in favor?
Aye.
You just keep your hands up.
All those opposed? Thank you. The motion carries 12-0.
Okay, great. So we will move on to the second item on the guidelines subcommittee report as the proposed clarification for cases involving mandatory consecutive sentences and their interaction with other guidelines rules. And Catherine Pembroke is going to lead our discussion on this. So let me just stop sharing my presentation. So Catherine can share.
So this memo provides the guidelines subcommittee recommendations to clarify the rules for calculating the overall upper limit of the guidelines when multiple rules apply. So as you all know, last May, the commission adopted the mandatory consecutive sentence rule. This rule applies to criminal events where the sentence for one offense is statutorily mandated to run consecutive to that of another offense. In these scenarios, the upper limit of the overall guidelines range equals the sum of the upper limit for the mandatory consecutive sentence offense and its underlying offense. With the adoption of that rule, we now have 4 rules that may apply when calculating the overall upper limit of the guidelines for a criminal event when there are multiple offenses. When the commission adopted the mandatory consecutive rule, there was no discussion as to how these rules would interact with each other. This came to the staff's attention when we had to dictate to our public safety programmers how to calculate these rules in MAGs. Now, the Guidelines Subcommittee is not asking to revise any of the current rules for calculating the guidelines. Rather, they're recommending that the full commission approve the instructions clarifying how these rules interact. The goal here is to avoid excessively stacking the guidelines in cases where multiple rules apply. To that end, the subcommittee recommended 2 clarifications to the guidelines manual and COMAR. One, that the mandatory consecutive sentence rule does not apply when there are 2 or more seriousness category 1 or 2 offenses. This is the rule that we already have in place when the multiple victim stacking rule applies. And 2, when both the mandatory consecutive sentence rule and the multiple victim stacking rule applies, the user applies the rule that results in the greatest upper guidelines limit. Now, this figure, also included on page 2 of the memo, illustrates the step-by-step process for determining which rule to apply when calculating the overall upper limit. For practitioners, assistant state's attorneys, and parole and probation agents who initiate the guidelines, this will all be done automatically by MAGs. They won't have to make any of these calculations themselves. First, are there multiple seriousness category 1 or 2 offenses in the criminal event? If there are, you stop there. The overall guidelines, upper guidelines limit will equal the sum of the upper guidelines limits for all of the seriousness category 1 and 2 offenses. If there is only 1 or no seriousness category 1 or 2 offenses, when you look at the other 3 rules to see which produces the greatest value for the upper guidelines limit. First is the simple scenario, which is where the overall upper guidelines limit equals the highest upper guidelines limit of the individual guidelines ranges. This is the rule that applies in about 98% of cases. Second is the multiple victim stacking rule, where the upper limit equals the sum of the upper limits for one offense per unique victim. Third is the mandatory consecutive sentence rule that we just discussed. So the memo includes 4 examples beginning on page 3. I'm going to walk through the first example. Here we have example 1, which involves committing a crime of violence in the presence of a minor, an assault first degree, and home invasion. We have 3 different victims. I crossed out the rule pertaining to more than 1 seriousness category 1 or 2 offense because that rule does not apply to this example. We look to see which rule results in the greatest upper guidelines limit. In the simple scenario, we take the highest of the individual guidelines ranges, which is 10 years, coming from the assault first degree. Well, as well as the home invasion, but 10 years. Under the multiple victim stacking rule, we add the upper limits for 1 offense per unique victim. Here, that equals 23 years. Under the mandatory consecutive sentence rule, we add the upper limits for committing a crime of violence in the presence of a minor, which is a mandatory consecutive sentence offense, and the assault, which is its underlying offense. That equals 13 years. So as you can see, the greatest value here comes from the multiple victim stacking rule. So the overall upper guidelines limit for the criminal event is 23 years, making the overall range 5 years to 23 years. The lower limit will always equal the highest of the lower limits unless there are multiple seriousness category 1 or 2 offenses. So that concludes my presentation. I'm happy to go over any of the other examples that are contained in the memo. The proposed revisions to the Maryland Sentencing Guidelines Manual and COMAR are on pages 7 through 11 of the memo. They detail the instructions that we just reviewed and provide users with an example case. If there are no further questions, I will turn it over to the commission for discussion.
Thank you, Kathy. So just to clarify, this does not change any guidelines rules. What we're asking for is just to adopt these clarifications that the staff we figured out we had to go through in order to properly tell the programmers how to get MAGs to do these calculations correctly. That was the most complicated part, to be honest. That took a lot of work on our end in order to be able to describe that to the programs. MAGs will do these calculations, okay? So it's not going to be incumbent on the users to figure this out. What we are asking for is the commission to just approve, because when we adopted this latest rule about the mandatory consecutive sentence, we didn't take into account the very rare circumstances where multiple of these rules, where the guidelines may get enhanced or stacked and come together. So we're just asking for clarification that we're saying you can't apply all of them. So this really is to avoid a situation where it might result in excessive stacking, where someone tried to apply the multiple victim stacking rule and the consecutive sentence rules, right? So we came up with these guidelines, and so we're just asking for the commission to approve these clarifications.
I can't remember if I had get off the call by then or not, but I thought everyone agreed with this one.
Yes.
Subcommittee. I thought so. So this was a unanimous
Correct.
from the subcommittee.
Are there any other questions? Any questions? Does somebody want to make the motion?
Move the recommendation.
Thank you, Doug.
All right, thank you. It's been proved, it's been moved and properly seconded to approve clarification of the multiple victim stacking provided by the commission for users. I think that's about as simple as that. All right, thank you. All those in favor? Aye. Any opposed? Motion carries.
All right, thank you. So I have 8 items to review. Keep it brief, Mr. I added one, but I just thought you would be interested in hearing it. It's very brief at the end. So first thing I just wanted to report, item number 1, on April 19th, our policy analyst, Lydia Becker, and I attended the annual Judiciary Conference. And by the way, it was co-hosted by our chair, Judge Middleton, and she did an amazing job. I heard lots of great things from your colleagues.
Oh, great.
So you probably get the job again. But Lydia and I presented a survey to the circuit court judges regarding the current list of common guidelines departure reasons. The purpose of this survey was to promote or discuss the commission's ongoing effort to review the list of common departure reasons. This was something that we discussed at this commission meeting in the past, and we did agree to go to the judicial conference, which turned out to be a great idea because we received 117 responses. They completed the survey on the spot. I don't think we ever would have gotten anywhere near close to that many responses. We just emailed it out. So we received some good feedback. Our plan, the staff is currently reviewing those survey responses, and we will be bringing this forward for the guideline subcommittee to discuss and probably have some recommendations at a future meeting. The second item I want to report, on February 1, since we last met in December, the commission issued an updated version of the Maryland Sentencing Guidelines Manual, and that included updates that were adopted by this commission in 2023. This included a mix from a couple different meetings, but the updates included the following. We newly adopted instructions related to the guideline scoring for offenses with mandatory consecutive sentences, which we just discussed. Modified instructions for scoring weapon presence for Part C of the offense score when the offense involves the presence of a feigned weapon. And then also additionally clarify instructions related to the guideline scoring for sentences to probation before judgment pursuant to Criminal Procedure Article 6-22C. That was, the change that came about with respect to PBJs, and so the commission provided that clarifying instructions. Finally, guided by Maryland case law, this commission also, and this went into effect on February 1, provided clarifying instructions that animals are not considered victims in the multiple victim stacking. That's something I'm going to come back to here later on in my report to talk about that. Sentencing guidelines training and judiciary feedback sessions. Just wanted to provide an update that in January, I provided a presentation regarding the sentencing guidelines and the goals and objectives of the work of this commission to a judicial college sentencing seminar that was attended by 39 judges from around the state. And then on April 4th, I participated in another judicial seminar that was on a separate topic regarding structural inequality. It was an anti-racism seminar that was put together by the judiciary. I provided just one portion of a larger judicial seminar on anti-racism, and I provided a summary of the Sentencing Commission's July 2023 report that assessed racial differences in sentences among those that are sentenced in criminal sentencing. Next thing I want to update is MAG's 12.0 deployment. Over the past year, and probably longer than that really, the staff has been actively working with programmers to update the Maryland Automated Guideline System, MAGS. And we are proud to report that we think we're very, very close. These forthcoming updates will enhance the overall function and usability of the application, including a more mobile-friendly format and new features such as simplifying the sentence screen to make it easier for judges and court staff to data enter the sentencing information. We're also adding a feature to recreate previously submitted worksheets for subsequent sentence modifications. So I think that's something that will be well received for when submitting worksheets for those modifications. And then finally, adding a feature to easily identify generally suspended sentences. This is something that we received feedback from judges and court staff around the state. And additionally, also to reflect the count number and worksheet ID on the worksheet PDF. This is something that was also requested to help make it easier for court staff. So those are all things that we're looking forward to deploying. We have a anticipated deployment date on or about July 1 of 2024. We're very close. The staff is currently working to finalize those updates and also to update all the corresponding training materials that have to go along with a rollout of a new application. So training videos, manuals, et cetera. But we hopefully by the July meeting will be able to report that has been deployed and hopefully has gone smoothly. The next item I wanted to talk about is to provide an update from the legislative session, just on 3 bills in particular that are relevant to the work of the Sentencing Commission. The first is House Bill 315, which was cross-filed with Senate Bill 319, and that requires the Maryland judiciary to report on the number of charges, convictions, and sentences for certain regulated firearm violations. This legislation repeals Section 6-215 of the Criminal Procedure Article that required the Sentencing Commission to complete that specific report on firearms. That requirement was established during the 2023 legislative session, and as you may recall, we discussed it here in our meetings, and we had sent, it was one of those things that happened on the last day of the session and really was assigned to the wrong agency. We don't have charging data, we don't have that information, so it wasn't something that the commission would be able to produce. Senator West and Delegate Bartlett stepped in and graciously offered to submit legislation during the 2024 session to revise that. That legislation did go through. It shifts those reporting requirements to the judiciary because really they are the only ones that can provide that charging data and information. So I want to thank Senator West and Delegate Bartlett, who's not here today, but Matt, so I just want to appreciate your efforts to introduce that legislation and support it and guide it through the adoption process. So thank you for that. Second bill I want to provide an update on is Senate Bill 17, or House Bill 667 was the cross-file. This is crimes relating to animals. So as I mentioned earlier, the commission last year, we adopted the change saying animals are counted as victims, and that was primarily driven by case law. And as you may remember, some of our members here said that might be a legislative issue to address. So there was legislation that was introduced. Again, Senator West again sponsored the Senate version of that bill. There was an amendment that came into that bill that provided that an animal shall be considered as an individual victim for the purposes of the sentencing guidelines, multiple victim stacking rule. So that was directly to address the decision that this commission made. So ultimately, that bill did not get through. It did not pass this session. So there's no action required from the commission at this time, but I really just want to provide an update on that. I don't know, Senator West. Wait till then. Almost. The last one that I want to talk about is Senate Bill 379. We talked about it a little bit, and I put a copy of that in your packet that was emailed to you. This is the task force to study crime reclassification. Senator West mentioned it earlier. This relates to the task force to study crime classification, which was originally established via Senate Bill 209 during the 2023 legislative session. It renames the task force to study crime classification to the task force to study crime reclassification and penalties. It requires the task force to study penalties for crime and civil offenses under state law, the potential need for reclassification of certain crimes, including whether common law offenses should be codified. the alteration of penalties, and whether certain changes should be made to crimes lacking an explicit mens rea. Senate Bill 379 also expands the membership, as Senator West noted, so they included a couple additional members to the task force, of which I would be one of those additions to the task force. So that's something that we'll be working on here in the upcoming year. The task force is set to meet on or after June 1, 2024, so coming up here pretty soon, and to report its findings to the governor by December 31st, 2025. So as an appointed member of that task force, I will partake in those meetings and report relevant updates to this commission, because I have, I'm sure they will have a lot of questions and be driven a lot by our classification system. I don't know, Senator West, if there's anything you would like to add. No. The next item I wanted to update on is the commission added a feature to our website on March 1st, and that's a data download tool that we added to the website that makes it even easier to provide even easier access to the available sentencing guidelines data. Prior to the launch of this tool on the website, data requests were submitted using an online request form on our website, and upon receipt of those requests, Stacy, who is our research director, which would follow up with the requester, confirm the request was received, and obtain any needed clarification on the specifics of the request. And then Stacy would ultimately generate a data file and provide that to the requester along with the data code book and a brief memorandum that described the provided files. The data download tool streamlines this process by allowing requesters to download the sentencing guidelines data and corresponding documentation, which again is that data code book and a description of the source and the scope of the data directly from the website. So it just allows it a little bit easier access to that information. And since that tool was launched a little over 2 months ago, there have been 9 documented data downloads, primarily by academic researchers and attorneys. Next item I want to discuss is our staff vacancy. We have been looking for a research assistant position. I'm happy to report that we received 49 applications for the position, which was tremendous. Much better response than we had when we had this position open 2 years ago. We interviewed 8 candidates, and we narrowed the list down to 4 finalists. And this week we are working to speak with their references, and we hope to decide on a finalist within the next 2 weeks. So if all goes well, we may be able to introduce the new staff research assistant at the July meeting. The last item I had that I added, I just want to discuss it. It kind of hit me that I should talk about this. I just wanted to share that the staff participated in the University of Maryland's College of Behavioral and Social Sciences Research Showcase event on May 2nd. So just last week. We are affiliated with the Department of Criminology and Criminal Justice at the University of Maryland. They are within the College of Behavioral and Social Sciences. This year's showcase featured research focusing on inequalities. And so it was appropriate for the Sentencing Commission to speak and present some of the work. We prepared a poster to highlight the work of the Sentencing Commission in general, and also to summarize the 2023 race report that was completed. So it was a great opportunity to share our work with attendees from across and outside the campus. So it was really nice it was a nice opportunity to showcase that research. So that will conclude my report. I'm happy to address any questions of their department.
Any questions?
Well, I think it's wonderful you were able to participate in that event. It's so, most people have no clue what we do here.
That is correct. So that was confirmed at that
But I think it's important.
So that's great. Congratulations.
Thank you. Appreciate that. Yeah, we definitely had a lot of explaining to do about who we are and what we do. We actually had that conversation a lot when people say, "What do you do?" And it's like, how detailed do you want the response to be?
Any old business?
I have 2 things.
Yes.
I'm not sure if it's old or new or whether I brought it up. But first, David reminded me I need to thank Stacy for providing me data for a case where I was trying to show in a proportionality review that a sentence was cruel and unusual. Stacy, before we were able to download it, provided all the data to me and some lessons on how to play with Excel to filter out data and make exhibits. And we have a ton, because I did the same thing with DC's data in the case. Our data is so much better. The DC was very limited in what I could get and how I could show it and multiple, set. They didn't put together, they put together by count, not by case. Made no sense to me. So if a person had multiple counts in DC, you couldn't put it together to show that they received this sentence for this case. Whereas we have, they were all together. But anyway, thank you very much. And it'll be even easier. The second thing I want to bring up, I want to understand something and preface it by saying the guideline subcommittee almost always, well, they always have worked to try to have consensus in whatever we bring back. So this isn't about that. I want to understand, we now have 5 members. The guideline, we've always had 4. So we have 5 votes now. I just want to be clear in front of the commission that there are now 5 votes because we have co-chair.
Yes.
Both will have full voting. I mean, just want to make clear that there are now 5 votes. Because I saw it.
That's correct. And the membership actually hasn't always been 4. It was 5 for quite some time. And then, I mean, really, it's at the discretion of the chair, determined for the last, 10 years, it's only been 4 members. But I think it does represent a good cross-represent, of the main memberships of the commission, and then we have a prosecutor, defense attorney, and a member of the legislature, and, 2 judges. So, yeah, but yes, that is correct.
Anything else?
I have an announcement to make if we're at the end. I know I've had a lot of talking to do, but there's just something exciting that I'm happy to share. So this year, 2024, marks the 25th year anniversary of the Sentencing Commission. Yeah, so we've been around for a while. It was created on effective July 1, 1999, with the adoption of House Bill 602 from the 1999 legislative session. The Maryland General Assembly created the Sentencing Commission as an independent agency to support fair and proportional sentencing policy and to maintain the state's voluntary sentencing guidelines. For those who don't know, prior to the creation of the Sentencing Commission, the guidelines were contained within the judiciary, right? So when the legislator created this independent commission, it was made up of a cross-section of representatives from all 3 branches of the government. In recognition of this milestone anniversary, we are sharing a very exciting gift of a coffee mug with the MSCCSP logo. We hope this mug helps you enjoy your coffee, tea, or whatever your beverage of choice is, while serving as a reminder of the important work that you all contribute to as members of the commission. So at the conclusion of the meeting, as a small gesture of appreciation of your work, we ask that you take a mug with you, and we thank you each for the positive and lasting difference that you make, that your service continues to make towards developing and maintaining fair and proportional sentencing policy in our state.
Well, thank you. That's an appropriate way to end the first meeting. I just want to say, this is my first meeting as chair. But I've had a chance to meet with and speak with several of you, and I just want to thank you all for helping this to be a very smooth transition. So thank you all. I appreciate everything you've done to help welcome me. But thank you so much. And with that, is there a motion to adjourn? All right.
Thank you, everyone.